Welcome to Medical Law and Ethics, Chapter 7, Medical Records, Informed Consent, and Health Information Technology. Over the course of this chapter, we will cover the following learning outcomes. We will explain the purpose of medical records and the importance of correct documentation, discuss medical records ownership, retention, storage, and destruction, describe the purpose of obtaining a patient's consent for the release of medical information, explain the doctrine of informed consent, and briefly describe the major components of health information technology. Here's a list of key terms that we will go over in this chapter. Medical records. Medical records are a collection of data recorded when a patient seeks medical treatment. Hospitals, surgical centers, clinics, physicians' offices, and other facilities providing healthcare services maintain patients' medical records. The purposes of medical records are they are required by licensing authorities and provide a format for tracking, documenting, and maintaining patients' communication data both inside and outside a healthcare facility. They provide documentation of a patient's continuing health care from birth until death, provide a foundation for managing a patient's continuing health care. They serve as legal documents in lawsuits, and they provide clinical data for education, research, statistical tracking, and assessing the quality of health care. Medical records often contain patient identification information such as name, address, phone numbers, email, marital status, driver's license, workplace information, and emergency contacts. Each patient is usually assigned a unique number by the treating providers. It will also have insurance information. So patients with private insurance, a copy of that current insurance card containing policy number and information will be included. Patients with Medicare will have an updated insurance card where Social Security numbers have been removed. Consent forms. These may include consent to treat, consent to disclose PHI, or consent to a special procedure. Clinical data. This is all the information related to the patient's condition, course of treatment, and progress. It may include patient medical history, physical exam, diagnostic or therapeutic orders, lab and radiology test results, referrals, and other clinical information. And lastly, other administrative information, treatment refusals, information about patient dismissal, documentation about missed appointments, follow-up calls, or any other information pertinent to the patient's care. The 5 C's of documentation. All documentation needs to be concise, complete and objective, clear and legibly written, correct, and chronologically ordered. Medical records should never include inappropriate personal judgments, observations, or attempts at humor. It has become very common in today's healthcare environment to use photographs or videotapes to add to a medical record. The old phrase, "a photo is worth 1,000 words," comes to mind. So they will take pictures of things like wounds, before and after care, or before and after pictures of cosmetic surgeries, other surgeries, videotapes that could be used later for education or review to see where different areas of improvement could be made. Photographs or video recordings without prior consent could be interpreted in court as an invasion of privacy. If a facility routinely photographs or videotapes patients to document care, a special consent form should be signed stating that the patient knows that the imaging will be used to document care. The patient understands that ownership rights to the images will be retained by the healthcare facility, but that they will be allowed to view them or obtain copies. Images will be securely stored for a specific amount of time, and images of the patient will not be released to outside agency without written authorization. If the images will be used for teaching or publicity, a separate consent form should be used. If corrections need to be made to written medical records, there is a proper protocol. First, you will draw a line through the error so it's still legible. So don't use whiteout, don't scratch it out. And then you'll write or type the information above or below the line or in the margin. You'll note why the correction was made. You'll enter the current date and time and your initials. And if possible, you'll have another person witness the correction and add their initials. For corrections to electronic health records, it is a slightly different process. First, do not obscure the original record. You don't want to erase it, you don't want to black it out. If you are adding new documentation, you would use an addendum. An addendum is a new documentation used to add information to the original entry. The addendum must clearly state the time period, the reason for the addendum, the actual information, and it needs to be signed and dated. An amendment is used to clarify or correct the information in the electronic health record. The amendment has the same information as above, so name, time period, the reason for it, and is used to either clarify or correct information in the electronic health record. Ownership of medical records. It has been the general consensus among healthcare providers and their legal advisors that healthcare provider or facility that creates a medical record owns the record. The patient, on the other hand, while not entitled to ownership of the entire document, is said to own the information contained in it. Patients do have some ownership traits, though, because they are able to, with written documentation, request copies of their medical record and distribute it to third parties. Under the doctrine of professional discretion, which is a principle under which a physician can exercise judgment as to whether to show patients who are being treated for mental or emotional conditions their records, healthcare professionals have the right not to release a record if it's in the best interest of the patient. Under HIPAA legislation, though, patients who ask to see a copy of their medical records must be accommodated with very few exceptions. If patients need clarification, records may be reviewed in the presence of a trusted healthcare professional, but this cannot be a requirement for allowing them to see their records. As protection in the event of a lawsuit, most medical records are kept until a specified statute of limitations. Usually this is between 2 and 7 years for adults. Most physicians will retain records indefinitely as they can affect future treatments. For minors, records need to be kept 3 to 5 years after reaching the age of majority, which is 21 in most states. Most facilities will establish a retention schedule to make sure they are keeping things long enough but clearing out space when needed. Destruction of the medical record. Destruction of PHI by a healthcare facility or provider must be carried out in accordance with federal and state laws. And experts recommend the process follow a written, approved retention schedule and destruction policy. While there's no one form of destruction approved, it must be destroyed with a method that provides no possibility of reconstruction of the information. Examples of common destruction methods are, for paper records, burning, shredding, pulping, or pulverizing. Microfilm or microfiche, recycling and or pulverizing. Laser discs are pulverizing. Computerized data, they're going to demagnetize it. DVDs, they're going to shred them or cut them. And magnetic tapes, they will demagnetize. They also need to maintain documentation of all destruction. Because healthcare practitioners have a duty to protect privacy of the patient, Medical records should never be released to a third party without written permission, signed by the patient or the patient's legal representative, and only the information requested should be released. Records release requests are usually for a specific time frame, specific diagnosis, symptom, body system, or certain diagnostic tests. Medical records personnel should be very careful not to send unsolicited records. They should carefully review the release form and make sure that only the correct records are sent. If records are requested for use in a lawsuit, a signed consent for the release of the records must be obtained from the patient unless the court subpoenas the records. In this case, the patient should be notified that they have been subpoenaed and released. Some routine release of medical information reasons are insurance claims, in which the authorization to release the information is usually incorporated into the patient forms at the beginning, so information can be provided in a timely manner. Transfer to another physician, in which case the physician may photocopy and send the entire record or may send a summary. Or for use in a court of law, when subpoena ducis tecum is issued for certain records, the subpoena commands the witness to appear in court and bring certain medical records with them. The patient's written consent to release these records is waived. If you end up with access to medical records, you need to be very diligent in only releasing them to those who have approved access to them. Family members, etc., still need to be listed as okay to release to. Don't just assume. If you have been tasked with providing medical information for a lawsuit, you need to make sure of the following things. First, make sure the name, phone number of attorney, and court docket number are all listed on the form. Verify with the attorney that the copy is the same as the original in every way. Verify that the patient named was a patient of the physician named. Verify the trial date and time on the subpoena. Notify the physician that a subpoena was received. Check that all records are complete, but never alter them in any way. Document the number of pages in the record and itemize the contents. And offer sworn testimony on record if so instructed by the court. Some state laws specifically address the release of confidential medical information, especially if it pertains to treatment for mental or emotional health problems, HIV testing, and substance abuse. In addition, the federal statute, Confidentiality of Alcohol and Drug Abuse Patient Records, protects patients with histories of substance abuse regarding the release of information about their treatment. Under no circumstance should the information of this type be released without specific written permission from the patient to do so. And only the information specifically requested should be released. The patient also has the right to rescind or cancel any consent to release information. A general guide for the authorization to release records would be as follows. The authorization should be in writing, and it should include the date on which consent expires. The authorization should include the patient's name, address, and date of birth. The patient or guardian should sign the authorization, and only the information specifically requested should be released. Requests for information should also include a specific description of the information that's needed and the purpose for which the data will be used. The patient also has the right to rescind consent anytime they want to. Consent. Permission from a person, either expressed or implied, for something to be done by another. In healthcare, consent is usually permission to examine the patient, perform tests that aid in the diagnosis, and treat the patient. The doctrine of informed consent is the legal basis for informed consent. It's usually outlined in a state's medical practice acts. It will include things like the proposed modes of treatment, why the treatment is necessary, risks involved in the proposed treatment, available alternative modes of treatment, risks of alternative modes of treatment, and the risks involved if the treatment is refused. Informed consent usually involves the patient's right to receive all the information relative to the case and make a decision regarding the treatment based on that knowledge. In order for informed consent to truly be there, you need to have feedback from the patient that they understand. And you need to represent both the benefits and the drawbacks of every side of the situation. People who cannot give informed consent would be minors or anyone under the age of majority, people who are mentally incompetent, or people speaking limited or no English. In today's hospitals, they have interpreters, so the last one is less of a concern because they have video interpreters, etc., to make sure that people who do not speak English fluently are able to fully comprehend what's being asked of them. Consent is considered unnecessary in emergency situations. If a healthcare provider or worker helps out in an emergency, they can be protected under the Good Samaritan Act, which is a state law protecting physicians and other healthcare practitioners and laypersons from charges of negligence or abandonment if they stop to help the victim of an accident or other emergency. For the Good Samaritan Act to be used as a defense, it has to have where they gave care in good faith, they acted within their scope of training and knowledge, they used as much due care as possible under the circumstances, and they cannot bill for the services after the fact. Health Information Technology, or HIT, is the application of information processing involving both computer hardware and software that deals with the storage, retrieval, sharing, and use of healthcare information, data, and knowledge for communication and decision-making. Health Information Technology and Meaningful Use. Meaningful use is using certified electronic health records, or EHR, technology to improve the quality, safety, efficiency, and reduce health disparities. Engage patients and family, improve care, coordination, and population of public health, and maintain privacy and security of patient health information. So the intent of health information technology is wide-ranging. They are trying to get faster, more accurate prescriptions, rapid information sharing, reduce paperwork, reducing unnecessary tests, better follow-up and better follow-through, and secure access to this information. So the secure access to this information a lot of times is through patient portals, which you can go online and check your own results. You can look up things such as recent doctor visits, discharge summaries, lab and test results, medications, immunizations, and even allergies. Make sure that these things are correct. Improve the quality of your record. It gives you faster access instead of waiting for the doctor to call you back. It also has features like online prescription refills, secure messaging with doctors, and online appointment scheduling. So health information technology and social media. Even the healthcare industry has seen the influence that social media can have on society. They estimate that Facebook has 2.2 billion monthly active users around the world, and Twitter has 321 million monthly active users. That is a huge audience. These social media sites allow people emotional support because they can reach out to people with similar healthcare issues. It can be used by researchers as an analytical platform to see where the needs are. It can build awareness of healthcare issues by putting ads into regular communications. It can have a voice in broadcasting opinions, so we can put out there things like flu shots and how important they are, now the new COVID vaccine and how important that might be. And it may capture patient satisfaction and feedback with surveys or opinion pages. Providers can also use text message reminders to remind patients of upcoming appointments, to refill their prescriptions. Health information technology and telemedicine. So the use of medical information exchanged from one site to another via electronic communications to improve a patient's clinical health status. These services include primary care and specialist referral services. So primary care physicians or other professionals can provide consultation with a patient and have a specialist assist through a video visit. Remote patient monitoring. Once referred to as home telehealth, this service can use devices to remotely collect and send data to home health agencies, remote diagnostic facilities for different interpretation. Consumer medical and health information. So organizations providing telemedicine can support specialized health information and online discussion groups to provide peer-to-peer support. Patient portals. As discussed earlier, patient portals provide an access online for patients to view their own results for lab tests, etc. And lastly, medical education. Targeting healthcare professionals in remote areas, telemedicine provides a way of continuing medical education and special medical education seminars to providers in remote areas. Technology also sometimes leads to threats to confidentiality. With the electronic transmission of records through photocopiers, fax machines, printers, and computers, you have to be very diligent to make sure that you have the right number, that things aren't left on a fax machine or printer for too long to where someone else can view someone's PHI or protected health information. And when computers get upgraded and replaced, we have to go through and destroy the records on those hard drives before the computer can be sold or recycled. Thank you for joining me for Medical Law and Ethics, Chapter 7, Medical Records, Informed Consent, and Health Information Technology.